This is Michael Clara coming to you from Salt Lake City, Utah. This video is titled Due Process for Natalie Cline, Part 1, at the Utah State Board of Education. An article from the dailymail.com sums up the unfolding story about the actions of Natalie Cline, who's a member of the Utah State Board of Education, and a Facebook post page which sparked political firestorm here in Utah that's been ongoing for the last 3 weeks. Just by way of introduction, back in the day when I was on the school board here in Salt Lake City, Superintendent Mikkel Withers waged a war on me to silence my voice on the school board. In the forefront of this photo here is me standing with Salt Lake City Police Chief Janetta Williams, and who's president of the NAACP. It is my intent to review the events of the last 3 weeks involving the Utah State Board of Education member Natalie Cline within the context of due process. I should also point out I grew up in Texas and went to school there before moving to Utah over 2 decades ago. While in Texas, I was elected as a mayor of a small town just outside of Austin. While serving as mayor, I fired the public works director and the police chief. And in those instances, I had to be schooled by the city attorney and members of the city council on due process rights that must be extended to the accused. So at the time, as a young mayor, no matter how much I thought the police chief and the public works director were wrong, and it was obvious that what they had did required them to be fired, we still, and I was taught this and learned this, that we had to still go through, afford them due process. Also, while serving on the school board here in Salt Lake City as an elected official, I was involved in a couple of high-profile cases where we did have to terminate somebody, and in a couple of cases I felt that people, actually we had to terminate several people, and those necessarily didn't make the news or were not public, but we had to afford people the right to respond to the accusations that were made. And there were a couple of times that some of them were high profile, where I felt that the people that the district was trying to fire was being dealt with unfairly. And in fact, a couple of those cases, even after I got off the board, ended up in the courts where I was a witness, and because they were civil cases, I had the opportunity to give depositions. And so my point is that I have experience in this from an elected official standpoint. What's required of us to, when we accuse somebody, whether they're employees or elected officials, they have a right to procedural due process. And this simple graph that I made here, I'm pointing out here that notice plus a hearing equals procedural due process. And in that procedural due process, that we have to give anybody that we accuse of any wrongdoing, they have to be given notice. They have to have the opportunity to be heard, meaning that you want to get their side of the story, and then a decision by a neutral decision maker. And in this case with board member Cline, there was a lot of people, people can say whatever they want. So there's a First Amendment right issue that I'm not talking about people. I'm talking about governmental entities that, and here's kind of a calendar that I made, or that I'll deal more with in part 2, that you had the governor, lieutenant governor, you had the Granite School District, these ones in red are the Salt Lake School District, Canyon School District, Jordan School District, all weighing in an official capacity on the nature of what board member Cline did, and officially accusing her of things. And then you have these ones in yellow, the Mill Creek, the Salt Lake City Council, the Salt Lake County Council, and the South Salt Lake City Council, the Midville City Council, all utilizing their offices and the weight of their office to render judgment on her actions. And in my opinion, in violation of her due process rights, because number one, those governmental entities didn't even have jurisdiction to even act on making a judgment on her actions. Now, in this case, there's a courts, which would mean that somebody, based on what she did, somebody could file criminal charges on her. That would come from the prosecutor. There could be a civil action, but those would go through the courts. And in this case, there was an action by the Utah legislature, which I would agree they have a right to do that. But in this instance, and in this part one, I want to go over the Utah State Board of Education. And they are 15 members on the board. They're elected. They have constitutional authority, and sometimes their makeup and how they operate changes based on whatever the current legislation is. But nevertheless, they have the right under Board Policy 2005 to implement the procedural due process for Board Member Cline and what her actions were. So here we go. That this is a graph that I made to kind of it's a policy that the Utah State Board of Education created 2005 back, I think, in 2021. And I kind of put this 7 steps of what the policy is on what is required in order to ensure due process of a board member that's been accused of some kind of violation. So let's get to it. This is the post on February 6th, earlier this month, that Board Member Cline posted on Facebook, and this is the extent of it. She posted about an upcoming basketball game, and she says girls basketball. And these are blurred just to protect the students and not to perpetuate this accusation that they're being exposed, to a lot of things by showing their picture. Board Member Cline, once she posted it on February 6th, the following day, she takes it down based on the reaction that she was getting in the comments, and she says here that she took it down. And one of the articles that came out about, there were several articles that came out, but the ones that I'll highlight here is like this, a story from KSL, because it talks about one of the things that I find interesting here is that at least we know the source of the posting from Board Member Cline. That it was a screenshot from an Instagram post advertising Tuesday's basketball game, as well as a picture of a banner hung in the gym, in the school gym, featuring basketball members. So so what the parents are telling the media is that this post that Natalie Cline did essentially is from an Instagram over here on the left, and then on the right is a picture that somebody took of the students, including their daughter, from a banner that was hanging in the gymnasium at the school. Now, in order to do that, the parents would have signed a release statement that allows that to happen. It allows it releases the school district of any liability, and that they're saying they're giving up their right to privacy for their student to be able to be on the banner, to be on the Instagram and on other social media events as an athlete. And that's pretty common here in Utah, that parents would do that. Or that's only done because the parents are allow for the photos of their students to be put in different social media and in different aspects of the school's athletic program. So on February 7th, this article comes out in KSL, and then on Thursday, February 8th. Now I'm leaving out a lot of things about all the other governmental entities like the governor and everybody who made statements, but I'll cover that in part 2. Right now I'm just covering what the Utah State Board of Education did. So on February 8th, these are the leaders of the Utah State Board of Education. They issue a statement, and they're basically saying that based on that Facebook posting that I just showed you, that that they're condemning, what Board Member Cline did. That as a leadership, we condemn the actions taken by Board Member Cline on a recent Facebook post directed towards a female high school student athlete in Utah. So they posted that. So I kind of just want to point out that, in my opinion, the USBE leadership, that's their right to do that. They have a right to make a statement because it's one of their board members. The only thing I would take exception to is here in the bylaws, it says that the board leadership may authorize any of the following. And I think that this statement that they did would fall under G, take other action. However, the bylaws are specifically saying that following adequate due process. Also on that same day that the statement came out, later on the news, you have Board Member Straight, who is a member of the Utah State Board of Education, and he says that, and again, this is before they even know, as a member of the board, that he even knows what Board Member Cline's response is. He said he wants to do the maximum possible, meaning punishment that he can do to Board Member Cline. And then also in that same news report, you have Carol Lear. And Carol Lear is she thinks she's the smartest one on the board because she's an attorney. She was actually an assistant attorney general, and prior to her being elected to the board, and I forget how many years, couple of decades that she's been on, and she reminds everybody of that, and she's the smartest one there because she used to be the attorney, now she's an elected official. But she says that that the greatest level of legal action, and not allowing board member Cline to speak at board meetings, not allowing her to speak at committee meetings, not allowing her to vote, and we need to speak against board members who really don't support public education. So she's made a determination that on Board Member Cline. Now, in contrast, you have Board Member Carey, who's asked by the reporter. The reporter says, I've had other members say to me, just take the maximum amount of action, whatever that is. Do you agree with that statement? And I love the response by Board Member Carey. He says, we have rules and procedures. And one of those is the application of due process. And that is where everyone is afforded this opportunity to say, here's my side of the story. As a board member, I will be one of those rendering judgment, and I don't want to do that prematurely. I've reached out to board leadership yesterday and today, urging them to call an emergency executive session where matters like this can be addressed. He says, I'm disappointed we haven't had one yet. And they end up, I think, the following day doing that. But kudos to Board Member Carey for having this mindset and this integrity, in contrast to what we just heard from Board Member Lear, already making judgments and deciding what should be done to Board Member Cline. So this to me is the model that elected officials should be following and should have at this time. So basically, going back to our question, does a tribunal have jurisdiction? As individual board members, they don't have any authority to do anything. And kind of what Board Member Carey is kind of giving us some good context and kind of sobering us up onto what should be happening. So again, here's the bylaws, and they can do things, but it's following adequate due process. So if we look at that graph that I had made earlier, that the steps are that you have Board Member Straight and Board Member Lear, you have the leadership making a statement even before they've heard from Board Member Cline as to why she made that Facebook posting. And then you have Board Member Carey saying, no, I'm going to play this safe and appropriately and wait and render judgment where I'm supposed to during the closed door meeting. And I think that I'm not going to go over what Board Member Cline said in her response, but I think one of the things that she had asked for is that members like this who already made judgments prior to her hearing, that they should recuse themselves. And if this was a jury, by the way, can you imagine if we're going to some trial and you have a juror on the news, because we know that the hearing happened on the 14th. So the week before the hearing, you have a juror already rendering judgment and saying, because in the state of Utah, the board members act in really in all forms of government, it would probably without the executive branch, but they acted as in the judicial role and in the legislative role. But here you have a quote unquote quasi juror the week before telling everybody, hey, I already got this figured out and I've already made a determination. In fact, I even know what the punishment should be for her. So this is the kind of stuff that I don't know what the solution is, but Board Member Cline did ask for several of the board members that said this kind of nonsense prior to her hearing to recuse themselves. Later on that evening on the news, the parents of the student that was in Board Member Cline's Facebook post, there were a number of, they were interviewed by everybody locally and even across the country. So they were pretty busy doing interviews. But one of the points that I want to bring out is that that while the reporter is at their house, here in this last paragraph says, minutes later, the phone rang again, and this time it was the daughter's coach offering the same level of support. And basically, since that morning, the parents said that it hasn't been hate that's been directed their way. Instead, it's been an incredible outpouring of support and love. The entire Granite School District has treated our daughter as if she were theirs. You couldn't ask for more. We've been surrounded by lots of goodness, which is a very positive thing. I'm bringing it up here to show that, in contrast, other governmental entities, as I'll point out next week, came to a different conclusion as to what was happening to this family and to this student. And then they also, at one point, the same evening on Thursday, talked about the fact that their child, quote, she's a tomboy. She dresses how she dresses. She's got a vibe. She's super cool, a cool style, and that she cuts her hair and she works out a lot at the gym, explained the dad. And then he says that when she's playing basketball, playing, sports in high school, just going to games, and then afterwards she's in tears, and we're like, what's going on? He said, she's like, oh, the student body who just yelling out names and saying, get the boy off the team, and he shouldn't be playing. So that's unfortunate that that's happening, but those issues should be addressed when they happen. He doesn't talk about that, but in my opinion, if there's taunting happening to the point that it brings a student to tears, then those should be investigated as they occur, and they shouldn't be allowed to happen. But it sounds like what I'm understanding, and by some other interviews, that this was a consistent thing that was happening to their child. They also said that, but again, in another story, the following day, and I believe this was from the Deseret News, they said that, so this was the on Friday, February 9th, what happens is the Granite School District, where they're at, has passed a resolution asking for Board Member Cline to resign and calling on all government agencies to do the same. But the parents' response is that they have been amazing since day one, talking about the school district. And what I love the most is that they're treating our daughter like it was their daughter. They're not treating her like a student or anything. These are parents, right? And they're treating her the same way that would, and so that's what's amazing. He said, walking into the packed room was overwhelming, meaning this school board special school board meeting that was called, and then last paragraph that the mom says that the support for their daughter that she's received has been amazing, but that we would rather fly more under the radar. She doesn't like all this attention, even though a lot of it has been positive. And so again, I want to bring that up because that's in stark contrast to what a lot of the conclusions that were reached by other governmental entities. They have a whole different story or a whole different perception or conclusion that they reach as to what this family and this student were going through. So here, I'm not going to spend any time on what Board Member Cline's responses were because they speak for themselves, and you can go back and read those. But I do want to point out that she, as we know, that the preliminary analysis 40 was created, and that these steps were followed, and that ensures due process. And as quirky as I think it is, or some of the problems and criticisms that I have of the process, it still is the process, and that's been agreed on, and that's in force. And in the state of Utah, when a board makes a school board, this is a state school board, but even on a local school board level, they create policy, and when they pass policy, it has the force of law within the district. And this is another response from Board Member Cline. And but the good thing is, in this particular case, that Board Policy 2005 ensures the procedural due process for Board Member Cline, and they're doing that. This happened on the 14th. I think I put on here, I kind of skipped over it, but here's the agenda for the meeting. So for Board Member Cline, the meeting was announced and scheduled for February 14th, and now kind of on the timeline ways, this is where we're at. And so she did another response earlier that day, and then the procedural safeguards are in place, but we got to have Sarah Reel she can't help herself, and she's gonna, in my opinion, violate the due process. And she says, this is, again, prior to the meeting. Before this meeting, we spoke to board member Sarah Reel, is what Lindsay Ertz, who said, who's interviewing her. And I think last July, we were able to determine I'm not going to go there. But anyways, board member Sarah Reel says, I'm really upset about the actions of board member Cline. And when her personal acts endanger and harm minors, that is something I consider beyond reprehensible. All right. So we got it. The juror is already made the determination prior to the court case even starting. So anyways, after I think they met 2 or 3 hours, and this is what the board comes out of executive session, and they come up with, this is the motion. They're going to ask for board member Cline's resignation, and then they issued a resolution, and they want these are the 3 things, number 2, 3, and 4, the things that the quote unquote punishment that they're going to met out towards board member Cline, and they say that these actions are consistent with the bylaws, and that they're going to these number 2, 3, and 4 are going to be in place until December 31st, 2024. So during the meeting, board member Bogus she requested that the resignation part of that motion be separated. And what she wanted to do is say, hey, I can support the other measures, but I don't think it's in our purview to ask her to resign. And they ended up voting that down, and it ended up being one motion. And so these are the things that ended up being passed by the Utah State Board of Education. So what I want to do is point out in the bylaws here that letter G, that what we're told, what the bylaws say that they can do is whatever they want, really. That taking other appropriate action leaves the door open, which is how the asking for the resignation is, in my opinion, a legal act, that it's appropriate for them to do, because based on the actions of a board member, they might have a list of A through, it's kind of a progressive list here, or one that escalates, that, A is, having a conversation, B is a written letter, and C is censoring, which they ended up doing through that resolution. And then D, prohibiting the member from attending, and they did that, D, E, and F. But they could have done a lot more. And based on the rhetoric that you heard from Carol Lear and from board member Sarah Reel, you just thought, well, they're going to really do things. And, you got Brent Strait saying, I want the maximum. Well, the maximum is, according to their bylaws, whatever you want. But the interesting thing is, based on all that rhetoric, this is what they came up with. Now, on the night of the board meeting, I didn't see what the resolution said. As you can see, in their motion, it says that the board takes the following action: issue the resolution of formal censure as presented. Well, as a member of the public watching the meeting from home, I didn't have access. I didn't know what the resolution was because they didn't release it to the public. They might have that night to whoever was there, but the public, as far as I know, didn't get it until the following day. At I think the time was on here. It was like at noon or something the next day, is when I was able to see a copy of a statement and the censure, the resolution that they actually did. But I want to make a point here that when you read their statement, one of the things that I find interesting, even first of all in the statement, it doesn't really accuse board member Cline or say that she's guilty of anything. It just says that an investigation was conducted in response to several complaints. And then it says that these actions were taken to uphold the standards set forth in Board Policy 2004, in board bylaws, and in the rules. And in the rules, by the way, here in the state of Utah, are procedures that are passed by the state board to implement state law. So in this case, when I read the statement, I'm like, that's really odd, based on all the rhetoric that's been going on but even again, if let's not even look at the rhetoric from other public officials, let's just look at the actions of the Utah State Board of Education. And as I've pointed out, you had members doing interviews, already passing judgment, but what ends up happening is way watered down from the rhetoric even coming out of the mouths of these Utah State Board of Education members, acting, in my opinion, prematurely. So when I read I looked at the resolution of censure, and I was, again, like, just wondering what's going on here, because it doesn't match what they were saying all these accusations were against board member Cline, which, again, I'm not complaining about it. I'm saying this is the reason why we should honor and respect the process of due process, because these are the people, number one, USBE, Utah State Board of Education members, are the ones that have authority to investigate the behavior of board member Cline. And based on that, this is what they have come up with. I did a records request for the preliminary analysis number 40 and haven't received it. So I'm waiting for, the response to my grammar request. But in the meantime, I went and pulled out preliminary analysis 26 that happened back in July, and I have a copy of it. And it was created in response to complaints following the same process about board members, Facebook post by board member Cline. And so I'm assuming that when they look at the policies, the policy violations that they analyzed against the Facebook posting, we're probably going to have the same results here. whenever I get a copy of preliminary analysis 40, I'm assuming that the audit committee is going to come up with the same conclusions, if you will. And so if I take the preliminary analysis back in July about a different Facebook posting and look how the application of a policy went, they say here that when you look at Article 411B and Article 5.4 of the bylaws of the State Board of Education, they conclude that determining whether communication or social media post is considered ethical or civil is subjective, and that the internal auditor is unaware of any rule or guideline standards in making a determination. That they also recognize that public education and topics related to public education are very political and may invoke strong feelings. So, and they're saying it's subjective then. But in their opinion, that there's nothing really set forth on what is ethical and what's not. So if I take the resolution of censure that the Utah State Board of Education just released on February 15th, that they voted on and approved on the 14th, this is what I'm looking at, is that I can start kind of overlaying it with the conclusions of the preliminary analysis from the auditors. And basically what I see here is at the top, they say that board member Natalie Cline violated board bylaws as follows. However, it's still they're not any more specific than that. That after that first line, that's it. They just kind of list a whole bunch of policies and bylaws. But as I'm pointing out to you, if I go take the preliminary analysis 26, and I'm anticipating that preliminary analysis 40 is going to draw the same conclusions about a Facebook posting, then one of these bylaws here, the 5, 4, and A, really is not a violation. It doesn't apply. So I'm going to take that out of the resolution. If I go on and look at preliminary analysis number 26, it says that Article 4, Section 2 of the bylaws is also not a violation by posting a posting on Facebook. And then they point out here, the one in July, which applies to the one here, that the post does not identify specific USB employees, local educational agency employees, a student, or individuals. So again, Article 4.2 of the bylaws has to do with identifying a particular, in this case, it'd be a student, but we know that Board Member Cline didn't do that. That she didn't identify, like, get a photo and then say, oh, this is the student's name and everything. The parents already did that. The school already did that. It was on Instagram. It was on a banner in the lunchroom. And so you can't, I'm marking it out here and saying, well, you can list it as a bylaw. And really that's all they do on this resolution is say, whereas, here's a bylaw. Well, I'm Xing it out by saying, making the argument, well, you can't hold Board Member Cline to that or say that she violated that, which number one, they say at the beginning that she did violate it. I'm going to say, you know what? She actually didn't. Okay. So, and here's why, so there's two sections on page 1 and 2 that they're claiming that she identified the student. I'm saying she didn't, that those were the school actually did that. So going back to the preliminary analysis from July, and they're looking at Board Policy 2004, and they say that the standard that saying that the board members, and again, we're looking at Article 5, Section 4 of the bylaws, that what the Internal Analysis Department has concluded is that board policy states that board members should hold themselves to a higher standard, and that that it's not a must, it's not a shall, is basically what they're saying, because it uses the term should instead of shall. Rather, statements are considered, protected under the First Amendment, that the board leadership is going to have to make that determination. But basically what they're saying is that when board policy says that a board member should do this, they're saying actually they don't, it doesn't say should. Or I'm sorry, it doesn't say shall, it says should. So that they can't be held to that standard. And this is back in July, by the way, they made that determination, and the board never changed it. So here we are in February, and they can put this in their censure of resolution, but technically she's not bound by that. It's not, she didn't violate it because it was her choice, or it's a board member's choice. Rather, they're going to follow that, which an educator does have to follow it. An elected official, a board member, is not bound by that. But even if you read this, it's like all they're doing is just listing what the rule says. And in my opinion, board member Cline didn't violate that anyways by what she posted, that all the things that are listed in this were not violated. Number one. Number two, they're not a requirement for board member Cline, and what the internal auditor said, you really can't hold a board member to that anyways. And so here's the sections that we would take out now from the resolution. The next thing in the preliminary analysis, it talks about Article 4, Section 3 of the bylaws. And this is the one in July, but I would assume it's going to apply to the Facebook posting here, that they didn't find anything that would cause any legal harm or risk to the board. But again, regardless, that's going to be up to the board leadership to make that determination in consultation with board's legal counsel. But they don't do that either. They never say in here how any of those that they claim, and this is here where I X'd out the part under for board policy 2004 and the things that they just list here, but they never tell us if the board member Cline violated that. And even according to the internal auditors, those wouldn't be violations anyways. So the next thing that we find in the resolution is that they talk about cyberbullying, and they don't even accuse board member Cline of doing it. They say that those that made comments did it. Could be construed, I think is the word they use, as cyberbullying. Well, here's by state law. If you go look at cyberbullying, the definition means using the internet, a cell phone, or another device to send or post text, video, or an image with the intent or knowledge of reckless disregard that the text, video, or image will hurt, embarrass, or threaten an individual, regardless of whether that individual directed, consented to, or acquiesced in the conduct, or voluntarily assess the electronic communication. And again, according to the resolution, censor resolution, this is what they were accusing the commenters of. So that's a state law. If there's a violation there, then charges should be filed against them. But I'm taking it out, Xing it out here on the resolution, because it wouldn't apply to board member Cline, because she's not the one that made those comments. And so here's the 3-page resolution, and based on comparing it or overlaying the conclusions that were made in the preliminary analysis back in July for different Facebook posting, I'm assuming that the new preliminary analysis, which they're calling number 40, is going to come to the same conclusions, because it's an analytical thing of the law or of the policy and its application of it. So if that's the case, this resolution that they passed on board member Cline, this is what it looks like. That their own preliminary analysis is going to neutralize these implied accusations, if you will, well, these aren't implied, actually. They say that she violated these aspects of the bylaws. But when you superimpose the preliminary analysis done by their own auditors, then these are the bylaws that she actually did not violate by posting something on Facebook. And a lot of what we're left with is the negative comments that they're saying, well, these negative comments happen, and that these are somehow they're going to, the board and this resolution. Now understand, well, let me make this point first, that board member Cline is saying, and the next day that, hey, I'm taking down this post. And she says, because some of the commenters talked about personal information as well as derogatory comments about the player were made by several commenters. And to protect the player, I removed the post. And she apologizes for actually the comments too, which I don't think are necessarily her responsibility for what other people wrote. But so anyways, what I'm saying is that when one of the other points I wanted to make is that we don't know what the original resolution of censure said. And I've been involved in this kind of stuff before, that the leadership or the superintendent or somebody says, well, here's, what I think we should vote on. And we're in a closed door meeting, and I can say, well, I'm not going to vote for that. I'm not going to, if you want my vote, you better take this out. And there were times where I would be the only one, not voting with the rest of the board. But if they want it, we would try to compromise and say, well, I can agree to this, I can agree to that. And I think that's what happened here, is that we got this watered down version, if you will, I'm assuming, of the resolution. And this is why the resolution, in my opinion, is weak in comparison to the rhetoric that we were hearing from other board members, from Lear, because when you go look at the rhetoric that Lear and even Sarah Reel was doing right before the meeting, minutes before the meeting, well, 3 hours later, that's not what the resolution says. And indeed, that once you, again, like I just did this exercise with you guys, once you overlay the internal audit conclusions about policy or bylaws and its application, well, those wouldn't apply to board member Cline anyways, or they shouldn't. And then all you're left with is the comments, the negative comments in the Facebook post. Well, you can't lay those at the feet of board member Cline either, because she is unequivocal that was the whole reason why she took down the posting. She says it right here. And she apologizes for it. She apologizes for what she did. She recognized that what she did was wrong to begin with, and that she took it down. But the impetus of taking it down also, according to her, was the comments. So really, here's what we're left with the resolution that was passed by the board, and the ones in yellow are the things, in my opinion, that stand. That the board, both as a body and individual, basically is what their position, what their authority is, and what they think board members should do, and then that they have the authority to implement some kind of punishment, which they did, and that whereas the burden of accuracy for content posted on social media resides with the poster, well, that's nothing wrong. That's not a violation or anything that board member Cline did. What she did was accurate. She just said girls basketball and posted what was on Instagram, and I guess some photo that somebody took of a banner that hangs in the gymnasium. And then at the end, they just say that board member Cline has 3 years experience. She was given the opportunity to respond to the charges, which she did, and that the responsibility and authority to impeach, to remove due to board member Cline's action resides with the Utah legislature, which is true. And be it therefore resolved that the board does hereby censure, disavow, and formally express its disapproval. They say that in the beginning, which is the extent of what they're saying. They just express their disapproval of what board member Cline's conduct described above. Guess what? Then they're of the same mind of board member Cline. Board member Cline removes the post, and she disapproved of what she did, and she says a lot of it had to do based on the reaction from the commenters. Well, the board and board member Cline are all on the same page. So, and again, next week you'll see when I post a video of what from the governor down to city councils and school boards and other elected officials said, it's in stark contrast to what the conclusion is of the board. that actually has the legal authority to judge our actions. And let's go back and look at what the motion was and how what it does. That here, we just went over the resolution that to me is basically doesn't do anything. And then they're going to remove board member number 2, remove member Cline from all standing board committees and any additional board committee assignments. Guess what? She's only on one committee, which is the Standards and Assessment Committee. And the few, probably 2 or 3 meetings that I've watched, they're always shutting her down anyways, and kind of ignoring her and kind of sighing and kind of being rude to her, if you will, which is fine. I'm not saying that's just part of being an elected official and participating in the politics of a committee, which is designed that way, to kind of come out with good policy making and stuff. But at any rate, my point is, she's no longer going to go to the Standards and Assessment Committee. If I was her, I would look at that as a blessing in disguise, that I don't have to go to a committee that they're abusing me all the time anyways. And really anything that she kind of changed or wanted to implement rarely happened anyways. So it's not a big deal. It doesn't change, I don't think, the outcome of that committee. And as you see here, they talk about committees and committee assignments. It's no plural here. It's only one committee that she was on, the Standard and Assessment Committee, and she's no longer there. I don't think it's going to make a difference for anybody. Maybe for her, she doesn't have to go. She has one less committee meeting. I believe they meet monthly, and boom, she doesn't have to go. And the next thing that they say is prohibit member Cline from placing items on upcoming board agendas. Well, according to the bylaws, Article 7, Section 5, 3 members have to request for something to be put on the agenda anyways. So board member Cline could never, as a single board member, get anything on the agenda anyways. She had to be one of 3. So in my opinion, that's not a big deal. That she can't get something on the, items on the agenda. She couldn't really anyways, without having 2 other board members there too. Number 4, prohibit member Cline from attending any board advisory committee meetings. Well, board members, according to in the bylaws, Article 5, 4E, board members couldn't attend advisory meetings anyways. Therefore, members may not attend, in blue here on the bottom, may not attend or participate unless specifically stated in statute or board policy. Well, in this case, that was it. Board member Cline, number 1, no board member could attend unless they were assigned an advisory group. And then she was assigned the Student Data Policy Advisory Group. I don't think they've met in over a year. I don't even know if that committee, that advisory group still exists. So my point is, you can see that what they meted out, the quote unquote punishment, is non-existent almost. It's like, that's it. And so my point is that whatever happened in that closed door meeting, they made the determination that her actions were not to the degree that of severity that all the hysteria was about. And so, that's something that, again, due process, we come out with something fair, and really nothing punitive happened to her by the USBE. So here on Monday, February 9th, moving on, February 19th, Lindsay Ertz, who kind of watches every move that board member Cline makes, and which is fine, which is good because we know what's going on. She says, "Oh, board member Cline just posted on Facebook she's going to run for re-election," and so what happens is the next day, one of the board members from my school board here in Salt Lake City School District. I'm not going to go into a big thing on this, but he's just saying, oh, you need to resign, that Board Member Cline needs to resign. And he says, and I'm going to go over more of this from each school district and city council and county council, what they did in order, to call for Board Member Cline's resignation. But I wanted to do this video first to show that in contrast, that they're really, number one, overstepping, overreaching as far as their authority goes, and they're ignorant. They don't know they have no clue what's going on, like the USBE, like the members of the state board did. So in this case, he says that, she needs to resign because she, what she did. And then he says that, that making a kid, he says that in his district, all the students feel safe in the Salt Lake City School District, and that's what they're about. And I just want to point out that's not true. He is delusional, because here I can go look on a public record. These are the pending cases of that are under investigation by the Office of Civil Rights, and those are the kinds of things I'll go over next week with the different school districts, that they're over here calling out for Board Member Cline to resign for nothing, really, based on the conclusions reached by her own peers. And then, but these local school districts, they got issues, and they have no business worrying about Board Member Cline. So in closing, the last thing I want to point out is that on Friday, February 9th, the Granite School District, I believe, was the first school district to pass a resolution and call for Board Member Cline's resignation. And understand that when the Granite School District does this is on the same day that the due process rights of Board Member Cline is being implemented, and the Utah State Board of Education's attorney has reached out to her via email and says, hey, give us your side of the story. Here are the allegations, and let us know what your side of the story is. So Granite School District doesn't even know what Board Member Cline's side of the story is. The student is in their district that was on the Facebook post, but they're going to pass a resolution calling for her resignation. Not only that, they're going to tell everybody, all the other elected officials, to do the same. One member who, and I've never met Board Member Kim Chandler from the Granite School District, but I admire her. And she is a standout elected official, just like I said about Joseph Carey on the state board. But here she says, that due process is, she's saying, first, I'm voting against this resolution. She says, calling for the entire state. How is passing a resolution calling on the entire state to condemn Natalie Cline and call for her resignation, all but ensuring a media spectacle sure to last for quite some time, will help our student? By the way, she was right on. She says, in addition to that, this resolution is asking for each of us to take a stance to convict and condemn someone without due process. She says, due process is always important and should be guaranteed to everyone, regardless of their views or actions they are accused of taking, or how guilty others may believe they are of those actions being, and elected officials does not strip someone of that right. In fact, I contend that as elected officials, we should be defenders of that right rather than complicit in its denial. For those reasons, and because of the high-profile nature of this issue, where they may be pending legal ramifications, I feel it would be rash for us to be weighing in on this matter, and I cannot support this resolution. Thank you. Wow. Understand that she says this happened on Friday, February 9th. It's not till the following week, on Valentine's Day, on February 14th, is when the USBE meets and actually collectively come to a conclusion that the things that Natalie Cline is being accused of are not valid. And so even if Kim Chandler wasn't right, even if the board, USBE, came to a different conclusion, board member Chandler is still right. You don't want to, all this stuff that was going on in her local board, passing a resolution and calling on everybody to call on Member Cline to resign is just wrong. It has no place. In our government, and our government officials should not be using their office and their power to do this kind of stuff. It's ridiculous. And you'll see, as I outline it next week, just how hysterical and unhinged people were about something that, in my opinion, things they were making up in their own mind. And it's fine for people to do that, or associations to do that, but government to do that is just insane. So thank you to these elected officials like board member Kim Chandler, who see the wisdom and recognize the role of government, and kind of, and is brave enough and courageous enough in the midst of being in the eye of the storm, if you will, to stand up and to be graceful about it and dignified, and it's just a powerful example. And I think it'll take, as the dust settles, people will realize how foolish they were and how wise people like board member Chandler were. All right, see you next week.